U.S. and foreign filing. For week 9, we're going to go over U.S. and foreign filing. Now, as I said, I think it was week 1, a patent and a trademark, for that matter, is good only in the country in which it's granted. So a U.S. patent will protect you from somebody making, using, or selling the invention in the United States, but it won't protect you from somebody making an invention in Germany and selling it to Mongolia, because you don't have a patent in Germany or Mongolia, so you can't stop that. Now, as a practical consideration for my smaller clients, if they make money in the U.S., that's probably good enough. And when you get a patent in a foreign country, you have to pay for the patent there, and then you have to pay the maintenance fees there, and then you have to pay to enforce the patent. And is it really worth it? So for most of my smaller clients, I usually advise them to just do a really good job in the United States, because depending on the world's economy, we have somewhere between 30 and 45% of the world's luxury buying market. And most of the stuff you've seen on my walls before, these are luxury items. We're talking about new wheels for your car. Well, some people don't even have cars. We're talking about, I'm just looking at the wall, we've got a travel mirror that doesn't break in a suitcase. Well, some people never have the money to travel. So again, if you can protect yourself in the U.S., that's usually good enough. But for larger companies and larger clients, they will want foreign protection. And so in the utility patent realm, there's the Paris Convention and the Patent Cooperation Treaty. And these are both ways where you can kind of piggyback a U.S. filed or another country filed application into a bunch of other countries. Paris Convention is almost never used except out of Australia now. So most people use the PCT, or Patent Cooperation Treaty. Now with the PCT, one of the main problems for your smaller clients is that it's costly. First of all, you have to prepare it and file it. Then you have to pick an ISA, which is an International Searching Authority. They prepare an ISR, which is an International Search Report. Now, the International Search Authority, they want some money to do it, obviously. They're not going to do this for free. And then it relates to the timing as well. So, for example, with a PCT will give you, in most countries, 2.5 years from the priority date. So let's say you file a provisional in the U.S., file the utility and the PCT at the same time, right when the provisional expires. Well, if you use the provisional to claim priority back to the PCT filing date, you got 1.5 years to file foreign applications. And so in a way, the PCT is kind of like an international version of the provisional, but in a lot of cases, especially with smaller clients, they're throwing $6,000 into something. And if you get a good ISR, an International Search Report, if they say that your invention is allowable, then that can be helpful. If they give you a negative ISR, well, believe me, that's the first thing the USPTO examiner is going to look at when they prepare their response to the office action. And their attitude is probably going to be, if it's not good enough for the PCT people, it's not good enough for us. And PCT, thank you for doing all the research and putting our arguments together for us. On the design patent side, there's something called the Hague Convention. Hague Convention is relatively new, and it's a way that you can piggyback a U.S. application or an application from any other Hague signatory to a number of other countries. The advantage is it has a fairly low upfront cost compared with hiring patent attorneys in each country to file these. The disadvantage that I've found so far is the program hasn't been around long enough for me to be super comfortable with it. And so right now I just had an issue with some drawings, and the examiner handled it with me by email, and there's like no formal record other than this email. And I'm kind of like, I kind of like to be able to look at things all in a column when I look up a patent application. But anyway, Hague will save your clients some money. So you want to become familiar with at least the PCT and the Hague, and get the idea of the approximate costs on what it's going to cost to go these two routes, and then be prepared to tell your client that, okay, this is what it's going to cost to get going. This is what it's going to cost to finish this up. And is that money really money that you want to spend overseas, because you're going to have to enforce it after you get the patents, or would that money be better spent on trade show booths and better websites and things like that in the United States? So just some considerations for foreign filing of patents.